Hi, this is Lee Cohen coming to you today from the Campbell and Brandon Sandy Springs office to talk to you a little bit about security deposits as they relate to temporary occupancy agreements. We have seen a huge uptick in sellers retaining possession of the property after closing in order for them to have more time to relocate and find a new place to live. With that, we've seen a lot of buyers who have requested money be held out of the seller proceeds for a security deposit in case there's any damage to the property during the time that the seller is occupying it after closing. And frequently they ask us as the closing attorney to hold that money in escrow. Now, neither us as closing attorneys or realtors want to hold the money in escrow. We're not parties to the temporary occupancy agreement, and the temporary occupancy is more akin to a landlord-tenant relationship where the landlord, i.e., the buyer, should be holding the money in escrow. The reasons that we don't like to hold the money in escrow are: one, the closing attorney is not in a position to mediate the dispute over the earnest money. If either of the parties are not cooperative, then likely there's going to be a dispute as to who gets the money at the end of the occupancy. And we're not privy to the facts. We don't know the condition of the property at the beginning or at the end of the occupancy, so we're not able to make a determination as to who's right and who's wrong. And if we can't make a determination, and if the parties are not mutually agreeable on how the money is going to be dispersed, we're going to file a lawsuit called an interpleader, where we're allowed by law to put that money into court and have the parties go to court to battle over it. With that, we're allowed to deduct our fees and costs associated with filing that interpleader action, and it's about $2,000. So right off the bat, there's going to be about $2,000 less in security deposits for the parties to fight over. Parties most likely would have to hire their own attorney, incur more expenses and costs, and trying to recover any part of the security deposit. The second part is that these security deposits, if held in escrow, would have to be on the settlement statement or the closing disclosure. And that has to go to the lender, and the lender has to approve that. And most likely the lender is going to have some objection to that, and maybe even think of it as some sort of a seller concession or other type of kickback, so to speak, that is not allowable on the settlement statement. As an alternative, the GAR Reforms Committee has come up with a great special stipulation, and it's in the GAR Forms, and it's GAR Form 416, if you want to take a look at that. And that's a very well-crafted special stipulation which contemplates and allows the buyer, as the kind of sort of landlord, to hold the money as security for any damage to the property. So at the end of the occupancy, the buyer would have to go through certain processes and procedures if they were going to keep any money. Otherwise, they would have to refund it back to the seller. So check it out. If you have any questions, we're here to help.